Right now, if you died tonight, your family could not touch a single dollar in your bank account. Not tomorrow, not next week. A will would not help them. A notary would not help them. An attorney-drafted estate plan would not help them. There is one free form, one that bypasses all of it. And the reason most people have never been told it exists is simple. Nobody whose job depends on the current system has any incentive to tell you. I've been a financial advisor for over 20 years. I've sat with more than 1,000 clients and their families, and I can tell you the single most preventable financial disaster I see isn't a bad investment. It isn't a tax mistake. It's a family standing at a bank counter the week after a death, being told they can't access a cent of money that was legally theirs because one form was never filed. That's my personal experience. That's why I can say this with certainty. That form takes 10 minutes. It costs nothing. It requires no attorney, and you'll never hear about it unless someone tells you straight. Here's what's changed just in the last few years, and why this matters more now than it did when your parents opened these accounts. Home values went up. Account balances went up with inflation. A savings account that sat comfortably under a state's probate threshold in 2010 is sitting right over it now. In 2026, more families are getting pulled into probate today than at any point in my career, and most of them have no idea it's coming until they're standing at the counter. The legal framework that still controls your money, the Uniform Probate Code, finalized in 1969 by the National Conference of Commissioners on Uniform State Laws, established something most Americans have never been told. It classified financial accounts held at banks and credit unions as contractual instruments, sitting on a completely separate legal track from your will. States adopted this framework over the following decades. Every state in the country now operates under some version of it. Courts have reinforced it in case after case ever since. Plain terms, the contract between you and your bank, not your will, not your trust, not your estate plan, governs what happens to your money when you die. A signed beneficiary designation on a bank form overrides a notarized, witnessed, attorney-drafted will every time. No exceptions. The will controls your furniture, your car, your jewelry, the physical property in your home. The bank contract controls your cash. If you die without a named beneficiary on your bank account, the account doesn't transfer to your heirs. It transfers to your estate. And the moment it transfers to your estate, probate triggers automatically. Probate is the court, supervised process of validating your will and distributing your assets under judicial oversight. Most states set probate thresholds between $50,000 and $100,000. If your account balance exceeds that, and for most retirees today it does, your family waits. The court moves on the court's schedule, not yours, not theirs. Here's what people don't understand about probate. It's not fast. Most states build in a mandatory creditor waiting period of 3 to 6 months. Unknown creditors, medical providers, credit card companies, anyone with a possible claim against the estate gets that window to come forward before a dollar moves. Your family can't receive anything until it closes. Doesn't matter how clean your finances were. And your bills keep running the whole time. The funeral doesn't wait. Grief doesn't come with a financial timeout. She did everything right. It didn't matter. Dorothy was 71. A retired school teacher from Illinois. She sold the family home and walked into her local bank with $350,000 from the proceeds, opened a standard savings account, hired an estate attorney for $800, had a comprehensive will drafted, witnessed, notarized, naming her 2 adult children, Michael and Sarah, as equal beneficiaries, put the will in a lockbox under her bed, called Michael, to tell him everything was handled. It wasn't Dorothy had a stroke and died. Michael and Sarah flew in, got hit with an $11,500 funeral invoice, and Michael walked into the bank with the death certificate and the notarized will. The branch manager looked at the screen, looked at the will, slid the documents back. Dorothy never filed a payable-on-death designation. The account held only her name because the balance exceeded the state's small estate threshold. The bank had no legal authority to release $1. A will is a letter to a probate judge. It carries no weight at a bank counter. The bank's obligation runs to the contract on file, and the contract on file named no one. The account froze. Michael and Sarah walked out with nothing, put the $11,500 funeral bill on their own credit cards, paying interest north of 20%, while $350,000 of their mother's money sat 20 feet away behind a counter they couldn't legally cross. Then probate started. Filing fee to open the estate, $389. Illinois requires a secondary publication to notify unknown creditors, run in a local paper for 3 consecutive weeks, $250, executor bond premium, $1,000. Those were just the entry fees. The probate attorney charged a percentage of the gross estate, standard practice in a lot of states, which came to over $10,500 on an estate this size. The mandatory creditor window held the case open for months. From start to finish, The family waited 14 months to access their mother's money. They lost over $12,000 in documented fees, and the interest on that credit card kept running the entire time. Dorothy didn't do anything wrong. She had the will, the notary, the attorney. None of it reached inside a bank contract. Her situation wasn't a legal error. It wasn't unusual. It was the entirely predictable result of a system working exactly the way it was designed to work. And it has 3 specific entry points where families fall in. Before I walk you through those, open your online banking right now, or pull out your most recent bank statement. Look for a beneficiary field if you can't find one, or it's blank. That's already your answer. Write down what you see, because it tells you exactly which of these traps you're sitting in. Failure 1. No beneficiary designation on file. This is the most common situation I run into. You opened the account years or decades ago. Nobody at the bank asked you to name a beneficiary. You signed the signature card and left. You assumed your will would handle it. It won't under the framework now codified across the country. A will has no authority over a bank account. The account defaults to the estate. Probate opens automatically for a lower income retiree. This is often catastrophic. A 6-month probate process on a $60,000 account can eat a meaningful slice of that balance before a single dollar reaches the family. For the comfortable middle-class retiree, the assumption is usually that the estate attorney already handled it. Most estate attorneys draft wills. They don't file bank beneficiary forms. 2 separate documents, 2 separate institutions, and almost nobody explains that to you when you write the check for the estate plan. Failure 2. An outdated beneficiary designation. More dangerous than no designation because it gives you false security. You named someone 20 years ago, an ex-spouse, a parent who's since died, a sibling you no longer speak to. That name is still on the form. That's who the bank sends the money to. The will says something entirely different. Doesn't matter. The Uniform Probate Code is clear in every state that's adopted it. The designation on file at the bank controls. Period courts have consistently ruled against surviving spouses, adult children, and estate executors who believed a current will would override an old bank designation. It won't. The bank looks at the form on file, not the document in your lockbox. Failure 3. The joint ownership assumption. A lot of married couples believe that because they're married, everything automatically transfers to the surviving spouse in a number of states. That's simply not true. Joint tenancy with right of survivorship has to be explicitly created and documented at the bank. Marriage alone doesn't establish it, and there's a trap hidden inside the most common attempt to fix this. Many seniors add an adult child directly to the account as a joint owner, thinking it gives the child easy access to pay bills if something goes wrong. The intention's good, the consequence is severe. The moment you add someone as a joint owner, the law in most states treats that money as partly theirs, right now while you're still alive. If your child is in a car accident and gets sued, the plaintiff can pursue your account. If they go through a divorce, their spouse can claim a portion of your savings in the settlement. If they owe back taxes, the IRS can levy your account to collect it. Joint ownership transfers your exposure to every liability your child carries, immediately and completely. The POD designation avoids all of it. It grants your beneficiary zero ownership while you're alive. Your money stays entirely yours, entirely protected from their creditors, until the moment you pass. Then the transfer happens cleanly on contract, no court involved. All 3 of these failures have the same fix, one form free available at your bank right now. The form is called a Payable-on-Death designation, or POD. The concept traces back to a New York court decision, Matter of Totten, in 1904, which established that money could transfer directly to another person upon death without a formal trust or court involvement. That principle was codified in Uniform Probate Code Section 6, 101, and adopted in some form across all 50 states. It's not a will, it's not a trust, it's a contractual instruction to your bank, operating on the exact same track that froze Dorothy's account. Because it runs on that track, it bypasses probate entirely. The bank never looks at the probate court. It looks at the designation on file. When a valid POD is recorded, your beneficiary presents a certified death certificate at the bank. The designation gets verified, the transfer processes, no judge, no attorney, no filing fees, no mandatory waiting period. Smaller banks may handle it same day or next business day. Larger institutions typically take 3 to 5 business days. What it doesn't take is 14 months. It costs zero. Every FDIC insured bank in the country is required to offer it. Every federally insured credit union offers an equivalent. No fee to file, no fee to maintain, because it generates nothing for the bank. It serves only you and the people you name. Here's where most people stop, and where most people leave gaps. The POD covers your individual bank accounts. Checking, savings, money market. It doesn't automatically extend to every financial instrument, even at the same institution. CDs need a separate designation. A CD sitting at the same branch as your checking pod isn't covered by that form. Each account is its own contract. Each contract needs its own beneficiary designation. 3 CDs at the same bank means 3 separate pod filings. Brokerage accounts use a different form, transfer, on death, or TOD. Same legal principle, but filed with your brokerage firm, not your bank. Stocks, bonds, mutual funds, with no TOD on file, go through probate, just like an undesignated bank account. Retirement accounts, IRAs, 401ks, 403bs, already operate on a transfer, on death principle by federal law, but most people filled out that designation when they opened the account decades ago and never revisited it. An outdated name carries the same consequence as no name, sometimes worse. Under federal law, a named beneficiary on a retirement account controls over any conflicting will or divorce decree. If your ex-spouse is still listed on an IRA you opened in 1995, they can legally collect the entire balance, regardless of your will, your divorce agreement, or how many years have passed. Review those today. One more asset worth mentioning, the safe deposit box. Many seniors store their will, deeds, and valuables inside one and hand the spare key to a family member. That key grants nothing after your death. Federal regulations require banks to seal safe deposit boxes upon notification of a customer's death, and your family gets denied entry even with the key in hand. If the physical will is inside the box, they face a circular problem. They need the will to open the probate case, but they need a probate order to open the box. The fix is free. Add your child as a joint renter on the safe deposit box contract at the branch. Both sign together, and they keep access no matter what happens to you. Here's what to do before you close this video. Step 1. Go to your bank this week, in person or through your online portal, and request the Payable-on-Death beneficiary designation form. Every FDIC insured bank has to provide it. If the teller doesn't know what it is, ask for the branch manager. Step 2. Name a primary beneficiary using their full legal name, date of birth, and social security number. No nicknames, no vague terms like my children. The social security number is how the bank verifies identity at transfer time. Step 3. Name a contingent beneficiary as backup. If your primary dies before you and no contingent is named, the account defaults to the estate and probate opens again. Step 4. Submit the form in person and request written confirmation it's been recorded. Keep that with your important documents. Step 5. Check every account separately. Checking, savings, each CD, all need their own designation. Step 6. Contact your brokerage and file a transfer on death designation for any non-retirement investment accounts. Step 7. Review your retirement account beneficiary designations and update any outdated names through your plan administrator. Step 8. Revisit all designations every 3 years, or after any major life event, a death, a marriage, a divorce, a new grandchild tonight. Your family still can't touch a single dollar in your account. That's true tonight, unless you file this form. The probate system isn't broken. It's working exactly as designed under the framework adopted from the Uniform Probate Code. The pod designation is the one mechanism that runs on that same contractual track and wins. Go to your bank this week. Ask for the pod form. It costs nothing. It takes 10 minutes. And if this saved you a headache, subscribe. I break this stuff down every week.